Hello everyone, Keith here. I'm back with part 2 of this case. I'll leave a link to this document down in the description below, along with our email. You can email us on PayPal at themahoney@gmail.com for private consultations. And yeah, I'm going to get right into this one. Reserve notes run counter to the fundamental law of the land, the Constitution of the United States of America. It appears on the face of it that the notes are ineffectual for any purpose, and that I am not justified in taking any steps toward the allowance of an appeal in this case. It is, however, the order of this court that the parties are entitled to a full hearing before this court, and if requested, a full hearing will be granted. Minnesota statutes annotated required that the applicant, First National Bank of Montgomery, deposit with the clerk of the district court within 10 days $2 lawful money of the United States for payment to the justice of the peace before whom the cause is tried. This is one of the conditions for the allowance of an appeal. 2 $1 Federal Reserve notes were deposited with the clerk of the district court. One was issued by the Federal Reserve Bank of San Francisco, bearing serial number, and the other on deposit was issued by the Federal Reserve Bank of Minneapolis, bearing its serial number. This court determined that said notes on their face were contrary to Article 1, Section 10 of the Constitution of the United States, and were also based upon the evidence deducted at the hearing of December 7, 1968, that the notes without any lawful consideration and herefore were void. However, this court indicated it would give the plaintiff, First National Bank of Montgomery, a full and complete hearing with reference to this issue. No hearing was requested by the plaintiff, First National Bank. This court was ordered to show cause before the district court. The order to show cause is as follows. Order to show cause. On reading the application for an order attached thereof, and on motion and affidavit of their Theodore R. Melby, attorney for plaintiff, do showing having been made that an exigency exists, it is ordered that Martin v. Mahoney, Justice of the Peace, Credit River Township, County of Scott, State of Minnesota, appear in person before the above court at 10 a.m. Friday, January 17, 1969, at the special term of Court of Scott, State of Minnesota, or as soon thereafter as counsel can be heard to show cause why he should not file in the office of the Clerk of District Court, First Judicial District, County of Scott, State of Minnesota, a transcript of all the entries made in this docket, together with all processes and other papers relating to the above identified cause of action, in his possession or the possession of any other justice of the peace of the State of Minnesota. Let this order application for order affidavit, all herefore attached, be served on Martin v. Mahoney, by leaving with him copies of the same and exhibiting this original order with the signature of the judge of district court thereof, a fixed service to be made forthwith. Dated at Chapogee, Minnesota, this 8th day of January, 1969. By the court is Harold E. Flynn, Judge of District Court. Therefore, upon motion of defendant Jerome Daly, this court ordered a hearing before this court on January 22, 1969 at 7 p.m. The First National Bank of Montgomery made no appearance all through service of the motion, and order was served upon Ralph Hendrickson, its cashier, on January 20, 1969. No continuance was requested by plaintiff on its attorney. The defendant appeared by and on behalf of himself. After waiting for 1 hour for the bank or its representative to appear the court received the testimony of the defendant bearing upon the issue of the validity of the Federal Reserve notes. Now therefore, based upon all the files, recordings, and proceedings therein of the evidence affirmed, this court makes the offering findings of fact, conclusions of law, judgment, and determination with reference to the allowance of an appeal. Findings of fact, conclusions of law, judgment, and determination. That the Federal Reserve Banking Corporation is a United States corporation with 12 banks throughout the United States, including New York, Minneapolis, and San Francisco. That the First National Bank of Montgomery is also a United States corporation, incorporated and existing under the laws of the United States, and is a member of the Federal Reserve System, and more specifically of the Federal Reserve Bank of Minneapolis. That because of the interlocking control activities, transactions, and practices, the Federal Reserve banks and the national banks are, for all practical purposes, in the law one and the same bank. As it is evidenced from the book, the Federal Reserve System is purposes and functions put up by the Board of Governors of the Federal Reserve System, Washington, D.C., 1963, and from other evidence adduced herein, the said Federal Reserve banks and national banks create money and credit upon their books and exercise the ultimate prerogative of expanding and reducing the supply of money or credit in the United States. This creation of money or credit upon the books of the banks constitutes the creation of the fiat money by bookkeeping entry. 90% or more of the credit never leaves the books of the banks, as the banks produce no specie as backing. When the federal banks and national banks acquire United States bonds and securities, state bonds and securities, state subdivision bonds and securities, mortgages on real property and mortgages on private personal property, the said banks create the money and create upon their books by bookkeeping entry. The first time the money comes into existence is when they create it on their bank books by bookkeeping entry. The banks create it out of nothing. No substantial fund of gold or silver is back of it, or any fund at all. The mechanics followed in the acquisition of the United States bonds are as follows. The Federal Reserve Bank places its name on the United States bond, and it goes to its banking books and credits the United States government for an equal amount of the face value of the bonds. The money or credit first comes into existence when they create it on the books of the bank. National banks do the same, except they have $1 in credit on hand for every $4 they create. The Federal Reserve Bank of Minneapolis obtains Federal Reserve notes in denominations of $1, 5, 10, 20, 50, 100, 500, 100, 1,000, 10,000, $100,000 for the cost of the printing of each note, which is less than 1 cent. The Federal Reserve Bank must deposit with the Treasurer of the United States a like amount of bonds for the note it receives. The bonds are without lawful consideration, and the Federal Reserve Bank created the money and the credit upon their books by which they acquired the bond. With their bookkeeping created credit, national banks obtain these notes from the Federal Reserve banks. The net effect of the entire transaction is that the Federal Reserve Bank and the national banks obtain Federal Reserve notes comparable to the ones they placed on the file with the clerk of district court, and the specimen of which is above, for the cost of printing only. Reserve notes a legal tender for all debts, public and private. Down to date, the Federal Reserve banks and the national banks are privately owned. As of March 18, 1968, all gold backing is removed from the said Federal Reserve notes. No gold or silver backs up these notes. The Federal Reserve notes in question in this case are unlawful and void upon the following grounds. Said notes are fiat money, not redeemable in gold, or silver coin upon their face, not backed by gold or silver, and the notes are in want of some real or substantial fund being provided for their payment in redemption. There is no mode provided for enforcing the payment of the same. There is no mode provided for the enforcement of the payment of the notes in anything of value. The notes are obviously not gold or silver coin. The sole consideration paid for the $1 Federal Reserve notes is in the neighborhood of the 9/10 of 1 cent, and therefore there is no lawful consideration behind said notes. That said, Federal Reserve notes do not conform to Title 12 United States Code sections 411 and 418, insofar as it attempts to make Federal Reserve notes and circulating notes of Federal Reserve banks and national banking associations a legal tender for all debts, public and private. It is unconstitutional and void, being contrary to Article 1, Section 10 of the Constitution of the United States, which prohibits any state from making anything but gold and silver coin a tender or impairing the obligation of contracts. Now therefore, by virtue of the authority vested in me, pursuant to the Declaration of Independence, the Northwest Ordinance of 1787, the Constitution of the United States of America, and the Constitution of the State of Minnesota, it is hereby determined, ordered, and adjudged that the appeal statutes of the State of Minnesota for civil appeals from the court to the District Court is not complied with within 10 days after entry of judgment. Therefore, the appeal is not allowed by this court, and my docket so shows. Memorandum of Law. The division and separation of the three great powers of government, the executive, the legislative, and judicial, and the principle that these powers should be forever kept separate and distinct from as vital importance to the maintenance and establishment of a free government, without which this republic cannot possibly survive. The particular wording of the Declaration of Independence, which set up an obsolete cutoff with the British form of government, is contained in the first two paragraphs thereof. Thereafter, the Constitution was ordained and established as a law for the government by the people of the United States. All legislative powers granted are vested in the Congress of the United States, consisting a House of Representatives and a Senate elected as representatives of all the people. Judicial power is defined in Black's Law Dictionary as an authority vested by courts and judges as distinguished from the executive and legislative power. Cases and controversies is defined in Black's Law Dictionary. This term is also used in the Constitution of the United States, embraces claims or continuance of litigants brought before the court for adjudication by regular proceedings for the protection of wrongs, and whenever the claim or contention of a party takes such a form that the judicial power is capable of acting upon it, it has become a case or controversy. Under our form of government, every American, individually or by representation, is the high and supreme sovereign authority. The authority at each of three departments of government is defined and established. It is entirely fitting and proper to observe that in all instances between the states and the United States and the people, there is no such thing as a idea of compact between the people on one side and the government on the other. The compact is that of the people with each other to produce and constitute a government. To suppose that any government can be a party to a compact with the whole people, it is supposing it to have an existence before it can have a right to exist. The only instance in which a compact can take place between the people and those who exercise the government is that people shall pay them or those who choose to employ them. Alright, I'm going to end it off here, guys, and I'll see you guys in the next video. Like, subscribe, and have a nice day. Bye.